So Bob is asking if all the vacancy tax we mentioned are in action now or if some are hold during litigation. So can't speak to the international ones, which we're still researching more about, but here in the US, all of the vacancy taxes are in action now. So there is litigation in San Francisco. But it's important to know, I think, a couple things on this front. Yes, vacancy taxes are legal. Washington, D.C., a city certainly with no shortage of lawyers familiar with the Constitution, has had a vacancy tax since 2010. So it's over 14 years without any legal challenges to the tax. Measure N was modeled primarily after Berkeley's vacancy tax, not San Francisco's. There are no legal challenges against Berkeley or Oakland's vacancy tax this time. And there's a number of really important differences between the two measures, many of which render the litigants' claims for the San Francisco's vacancy tax irrelevant for Measure N here in Tahoe. But speaking to San Francisco's, I know a lot of people have questions about this. So the city of San Francisco's team, and this is actually outlined in the city's report, has making a really effective legal case that their excise tax is neither a takings, either a violation of a takings claim or a violation of the Ellis Act, as the measure seeks to encourage owners to occupy, inhabit, or use, so their language, their residential units for more than 182 days per year, and does not require owners to rent their units. And they cited that similar local ordinances have been upheld by the U.S. Supreme Court. So yeah, I think that and the other piece about San Francisco is it's still moving forward while in litigation. So to answer Bob's question, no, none of them are on hold. Let's see, there's a question here about if litigation could cost the city millions. And the answer is no. The city actually included this in their impartial analysis. Estimated legal challenges were around estimated $100,000. It's a small percentage of the revenue that the policy could bring in. In addition to that, I think there's been a lot of folks talking about how the cost for any litigation can be covered by the measure. And so they can be paid back if those need to be covered in advance by Measure N. And then I think it's really important. I don't fully understand the pushback, which is the measure is designed to be fully self-sufficient. So that means covering cost for administration, covering cost for any litigation. I think that's usually the sign of a good policy, that you don't need to be pulling funding in from other sources. But we'll continue to take questions about that. I think that was the one I saw here.